I'm County Executive Chris Ronayne. We developed the Great Estates program to help Cuyahoga County residents prepare for settling an estate. We know you probably don't want to think about what happens to your assets after you pass or how to settle a loved one's estate, but we've got information that will help you save a lot of time and expense during a difficult time. We hope this is helpful.
Hi, I'm Judge Laura Gallagher, and on behalf of the Cuyahoga County Probate Court, Judge Anthony Russo and I are happy to partner with the county in providing this Great Estates program. From my own experience, I can tell you that the loss of a loved one can be debilitating. While you're trying to spend time with family and process the loss, suddenly you may find yourself going through files, looking at financial information, getting involved with the court, all the filing requirements, the time deadlines. It can be overwhelming, and there are ways to avoid this, and that's why we thought this program might be really a good thing to share with all of you. If you own a home, a car, if you have bank accounts, investment accounts, insurance policies, retirement accounts, this is a good time to review how those assets are owned. If you own those things in your own name only, when you pass, those will have to be handled through probate court. However, you may be able to have designations to avoid probate court, and with regard to your home or your vehicle, other speakers are going to address those kind of assets and what you can do. I'm going to talk to you first about bank accounts. If you own a bank account or multiple accounts in your own name, it may be as simple as visiting your local branch and asking to fill out a form naming payable on death beneficiaries for your account. If you do this, upon your death, the beneficiaries would simply need to take a copy of the death certificate to the bank to receive these funds. There's a difference between a payable on death account and a joint and survivorship account that you should be aware of. A pay on death account means you own that money until you die and then it transfers. However, if you set up a joint with survivorship, the person you name on your account would have access to your account while you are alive. So I would caution you to be careful with that approach. With investment accounts, insurance policies, retirement accounts, you may be able to simply go online to name your pay on death designations, or you may need to fill out a form and send it to the company. Either way, the effort that you put in now may avoid having your family members have to go through the probate court process to receive those funds. I think it's also important to name contingent beneficiaries. So an example of that would be you would name your spouse as your primary beneficiary, but also maybe name your children as contingent beneficiaries. That way, if your spouse dies first, the paperwork is already done for that money to be able to transfer to your kids. I personally experienced this with my parents. They had done some planning. They had named each other as beneficiaries on all of their accounts. And when the first parent died, it was easy enough to transfer all that money to the other parent. Unfortunately, my second parent died very shortly after my first parent, and there was no time to add contingent beneficiaries, so we ended up in probate court nevertheless. From that experience, I can tell you, probate court's not the worst place to be, but if you can avoid it, that's the best way to go. People often ask whether they should consider creating a trust. Trusts can be beneficial for controlling your assets from beyond the grave, and there may be tax benefits. However, there are various kinds of trusts, and they can very quickly become complicated. I would suggest talking to an experienced estate planner who could determine what is best for your situation. What you can do on your own, however, is to plan for transfer of real estate.
My name is Brian O'Malley. I'm Director of Transfer Recording for Cuyahoga County, and I want to welcome you to the Great Estates program. The most important thing I always tell people is make sure to look at their current deed. There are currently two types of tenancies available under Ohio law, the survivorship deed or a transfer on death affidavit. On any deed you have, you should be able to see what type of deed it is. Survivorship basically is what it sounds like. Two or more people can own property in a survivorship tenancy, and if one of them were to pass, it automatically reverts to the remaining owners. Transfer on death designation, it is you can name your beneficiaries now, and instead of having to go through probate, it will transfer directly to your heirs at the time of your death. Now, any deed can create a survivorship tenancy. An executor deed, it might say fiduciary deed, it could say warranty deed. It can still be a survivorship deed as long as it has that language after the grantee's names where it would state and to survivor of them. The affidavit basically states that you and your spouse or you and your co-owner own this property, you purchased it on a certain date, and you can name the beneficiaries that you would like to inherit your property upon your death. The other advantage is you get to decide how they would inherit it. So as I mentioned, they could be survivorship tenants or they could be what's called tenants in common. So tenants in common is basically like they have an undivided percentage interest in the property. So if you had 3 children and you listed all 3, each would get 1/3, and if something were to happen to them, it would go to their heirs. If survivorship, then it would just go to the remaining 2. So it gives you a lot of flexibility how you want to set up your estate and how you want people to inherit the property after you're gone. Now, once you're in a survivorship tenancy, and if unfortunately one of the owners were to pass, it's a very simple form you could come into our office to file. The only thing you need is a copy of the certified death certificate, and you can come into our office, and it's called an affidavit of surviving spouse or joint survivor. Again, you would just need a certified copy of the death certificate, come into our office, and we would help you with the rest. A question we get often is about people who have family trusts. If you already have a trust in existence, you can actually list them as the beneficiary on a transfer on death deed. We always caution to make sure that you list it correctly, because a trust cannot hold title by Ohio law. So you cannot put the Smith Family Trust. You would put John Smith, trustee of the Smith Family Trust, under dated trust and the date that it was created. It's very important that you list that correctly, because that could possibly cause a cloud on your title. Anything you need help with, please contact our office, 216-443-7020, and my staff will be more than happy to help you review your deed, help you with property alert, or any of the things we've talked about, and answer your questions.
Hi, I'm Nicole Sanders, Auto Title Division Manager for Cuyahoga County. And today I'm going to share with you your options on how you can handle your estate planning for your automobiles, watercraft, recreational vehicles, and other titled possessions. Your first option is the Transfer on Death Affidavit. It allows your possessions to be transferred to one or more beneficiaries. These beneficiaries can be added or removed at any time. They can be an individual, a corporation, a trust, an organization, or any other legal entity. They can also be minors. It cannot be added to a title with a lien unless permission is given by the lien holder, but it can be added to a title with the WROS notation on it. WROS, or with rights of survivorship, allows your titled possessions to be transferred to the surviving joint owner. It can only be added to the title if both owners are living, and there must be 2 owners on the title in order to add WROS. It can be added at any time and can even be added if there's a lien on the title. And there's no extra forms necessary. It's simply an extra notation listed on the top of the title next to the 2 owners' names. Your final option is the surviving spouse. It allows your titled possessions to be transferred to your surviving spouse without having to go through probate court. It only applies to motor vehicles, watercraft, and outboard motors. Unfortunately, it does not apply to mobile homes, recreational vehicles such as ATVs or UTVs. It is not affected by a title with an active lien, but you can only transfer $65,000 worth of property. When you come into one of our offices attempting to file your surviving spouse paperwork, we will ask you at that time the value of the vehicles that you are trying to transfer. As long as they are under $65,000, we can get that taken care of for you as long as you have your supporting documentation. All of these estate planning options can be handled at any one of our 5 auto title locations located across Cuyahoga County. We're open evenings and Saturdays and are more than happy to help you with any of your needs.
I'm Cuyahoga County Fiscal Officer Michael Chambers. Thank you for your interest in our Great Estates program. We are very proud of our program, and we are happy to share this information with you. We know many of you don't want to think about your assets after your pass, but our kit will help your loved ones save time and money during a difficult period. If you have questions about the program or need assistance filing of the affidavits, our fiscal staff is here to answer them.